Greetings again, class. So we are moving on with our video lecture series. In this portion, we are to talk about two special laws under the law on sales. First off, we're going to tackle on the Recto law, and then on the second part of this video is the Maceda law. Now, take note that the Recto law pertains to installment sales of personal properties, whereas the Macedo law pertains to installment sales of real property, okay, or real estate, including residential condominium units. Now, Recto law is incorporated already under the new civil code. New Civil Code of the Philippines by virtue of Article 1484. Okay, whereas Maceda law is a special law which supplements the provisions on sale embodied in our civil code. Now, the essence of these two laws are actually as a form of protection to the consuming public, no? Because the buyers, no, are not in equal footing with the institutional sellers of personal properties and real estate. No? So Article 1484 limits, no, for under the Recto law, limits the option of the vendor or the seller in case the buyer fails to pay on installment its amortization. No? So take note, there is the sale presupposes the existence of an installment sale. So definitely sale on straight terms is not included in this provision. So for example, you enter into a deed of sale of personal property, and then one half or a portion of the payment shall be paid upon the execution of the contract, and then the remaining balance shall be paid on a future date. That does not encompass installment sales. Okay, installment sales encompasses payment of down payment and then interval of payments, no? Which might range to months or even years. Okay, so in case of default by the buyer, the seller is given three options. Uh, Number one is exact fulfillment. What do you mean by this? No? So the entire balance remaining under amortization shall be fulfilled by the vendee, okay, by the buyer. Should the vendee fail to pay any of the installments, so that's also an important factor. Number one option does not inquire into how many installment payments was already made. No? So any installments not paid by the buyer, the seller is allowed to exercise option one. Now, alternatively, I said alternatively because these are alternative remedies of the seller. He cannot exercise all of this. He only has the option to choose one. Okay. Now, alternative to number one is that the vendor or the seller might cancel the sale, no, rescission of the contract. Should the vendee's failure to pay cover two or more installments. So this would only come about if the buyer fails to pay two or at least two installments, so two or more installments. So there is mutual restitution of the cost and consideration of the contract of sale. Number three option is foreclosure of the chattel mortgage. No? So the security or the chattel that will secure the installment payments will be foreclosed in favor of the vendor. No? If one has been constituted, should the vendee's failure to pay cover two or more installments. So just like option number two, option number three also is applicable if the failure encompasses two or more installments. No? So in this case, he shall have, this is a very important, this portion here is very important provision, no? He shall have no further action against the purchaser to recover any unpaid balance. Because if you apply the chattel mortgage law, it's a different ruling. But in this case, Article 1484 mandates that if the vendor chooses the third option, the forecloses of the chattel mortgage, there shall be no further action whether or not the chattel mortgage proved to be sufficient in payment of the balance. Okay? Any agreement to the contrary shall be void. Okay, so that's very clear. Again, these options are in the alternative. Okay, in the alternative. Now, to further clarify the applicability of Article 1484, we go to the case of PCI Leasing versus Giraffe X. Now, this is a case where PCI Leasing leased several equipments in favor of Giraffe X. Okay, so there was a leasehold agreement between the party. Now, long story short, Giraffe X defaulted. He was not able to pay the rentals, the rentals in as a consideration for the use of or for the lease of the property. So as a result of that, PCI Leasing sent a demand letter against Giraffe X. Now, in that demand letter, there was a certain statement there which states the payment of the full amount of the unpaid balance for the entire lease period or to surrender of the financed asset. So PCI Leasing essentially gave option to Giraffe X. Okay, so it's either Giraffe X shall pay the full amount of the unpaid balance or to surrender the asset pertaining to the lease. So in other words, in that demand letter, the interpretation is, should Giraffe opted to pay the balance stated, it need not return the subject equipment. Likewise, if Giraffe opted not to exercise its option of acquiring the equipment by returning them, then it need not pay the outstanding balance. So according to the Supreme Court, the legal import of that provision is that the transaction at hand is actually a lease in name only. The so-called monthly rentals are in truth monthly amortizations of the price of the equipment given the above. So the Recto law should apply. So the Recto law also applies even if in name the contract is a lease, but in reality, it is a leasehold with an option to buy the property. So the leasehold payments or the rental payments are now converted into amortization for the payment of the property. And since PCI, in choosing to deprive Giraffe of the possession of the equipment, waived its right to bring an action to recover unpaid rental. So for paragraph 3 of Article 1484 applies in this case. Okay. So in choosing to get back or to recover the asset, PCI Leasing cannot anymore go against Giraffe X for the payment of any unpaid balance. Otherwise, that would be a direct violation of paragraph 3. Take note, class, in the last portion of paragraph 3, it states there that the vendor shall have no further action against the purchaser to recover any unpaid balance. So that applies in this case. Now, another case, we go to Equitable Savings versus Rosalinda. So because there has been a lot of misconception on this. Now, I know that at least one of you have acquired a car loan, diba? So you go to Toyota, you choose a car of your liking, or even to Honda, and then you don't have the money, but you have the money for the down payment. So what you do is that Toyota or Honda will assist you in looking for a bank to finance your purchase of the car. So what actually happens, class, is that uh, your payment will go to the bank because it is the bank who will pay Toyota or Honda the full cash value of the property. Now, in that case, Article 1484 does not apply because your relationship with the bank is not an installment sale of personal property. It is more properly uh, to be considered as a loan contract. No? So this is what the Supreme Court enunciated in the Equitable Savings versus Palaces case. So there was no vendor-vendee relationship between respondent and petitioner. Now this is between the buyer, the mortgager, and the bank. Respondent merely sought financing from petitioner for its full purchase price. Indubitably, a loan contract with a chattel mortgage contract and not a contract of sale of personal property and installment was entered into by the parties. So Article 1484 is not applicable. Okay? So be very careful in your analysis on that. So usually naman pag mga car dealers, they don't usually provide in-house. I don't know with I think Toyota has an in-house. I'm not sure, no, but usually it's, also for to safeguard their interest, they usually refer you to a bank, no. At least per my experience, no. So they refer me to BPI, and then BPI and I will enter into a contract of loan. Okay? So 1484 does not apply to car loans. Now, again, no, the remedies under this article, the Recto law is availed as an alternative. It's not cumulative. So the failure of one would bar you from the exercise of the other option. Take note, the first option is applicable on any failure to pay any installment. But option 2 and 3, it will only arise when there is failure to pay 2 or more installments. Now, the general rule is that this is the barring effect. The limiting language of Article 1484, which uses the phrase any unpaid balance. No? So the last paragraph, this one, no further action against the purchaser to recover any unpaid balance. That phrase, class, includes interest, attorney's fees, and costs. No? So it encompasses everything. No? So the unpaid balance encompasses everything. Exception is when a defaulting buyer refuses to surrender the chattel. So because of his refusal to surrender the chattel under the option 3 availed of by the vendor, the seller was forced to proceed with the foreclosure. No? So nag-extra effort tuloy siya to proceed with the foreclosure, forcing the buyer to give up property. Like for example, he was forced to file a case in court, okay, in order to exercise the third option. Then in this case, the seller, even after foreclosure, should be allowed to recover expenses and attorney's fees incurred in trying to obtain possession of the chattel. So magpa-file yan siya ng recovery of possession ng replevin, no? The writ of replevin. So that is the exception to the general rule on the barring effect. Now, so we are through with the Recto law on the installment sales of personal property. Now we go to Maceda law, a special law supplemental to the Civil Code provisions on sales, Republic Act number 6552, enacted by the former Senator Ernesto Maceda. Okay. Now, Recto law was enacted by the former Senator Claro M. Recto. Okay, so now, the purpose of the Maceda law is an expression of public policy to protect buyers or real estate on its installment against onerous and oppressive conditions. So, there should be greater protection for installment purchase of real estate because for one, it's actually an investment on the part of the buyer. Because real estate encompasses largest value and generally real estate increases in value with time. Okay, now what are the requisites to be applicable with the Maceda law? Okay, so the transaction must involve a real estate, so it includes a house and lot, okay, including residential condo units. Okay, number two requisite, so in other words, commercial lots are not included in this equation. Okay, number two, buyer defaults in payment of succeeding installments. So in the Recto law, klaro yun, no, 2 or more installments. In the Maceda law, it's different, no? So, what are the rights of the buyer under the Maceda law? No? So, if the buyer, the first scenario is this, if the buyer has paid at least 2 years of installments, okay, 2 years of installments, so these are his options, or these are his rights, no, which he can exercise. Now, these are not in the alternatives. These are all available to the buyer. So there are 4 of them. Now, number 1 is that the buyer is given to pay without an additional interest. So pag nag-default yung buyer on any of the amortization and he has previously paid at least 2 years of installment, he is given a grace period. Okay, so the grace period is 1 month for every 1 year of installment payment. So take note in this first scenario, at least 2 years na siya, diba? So let us say the buyer has already previously paid 4 years of installment. So he will have 1 month for every year. So he will have 4 months of grace period. So the mortgagee will have to give him 4 years, 4 months. So that's around 120 days to a chance to pay without additional interest. Okay. Now, second, so let's say that despite of that grace period of 30 days or 120 days in this case, the buyer still failed to pay. The buyer still failed to pay its amortization. So we now move on to the act of cancellation of the contract of sale. But before that, the buyer is given another 30 days. Okay? So as a matter of due process, okay, the seller shall give the buyer a notice of cancellation. And this cancellation shall be given to the buyer notarized. So the notice of cancellation must be notarized by a notary public. Okay? Now, when the buyer receives the notice of cancellation, the actual cancellation of the contract can take place 30 days from the receipt of the notice of cancellation. Now, take note, this is another, I think, grace period on the part of the buyer. Because pag na-receive niya yung notice of cancellation, hindi yun automatic. He is still given another 30 days from that notice to reinstate the contract, to give him more time to pay and settle his overdue account before the actual cancellation, and upon full payment of the cash surrender value. So there are twin requirements that the seller must do. This is after the lapse of the grace period. This comes in after the lapse of the grace period. Notice of cancellation must be given to the buyer. He must be given 30 days from actual receipt of the notice before the actual cancellation can happen. And aside from that, there must be full payment of cash surrender value. Now, ma'am, what if na-notify yung buyer ng notice of cancellation and we are now on the 31st day? Magkakaroon na ba ng actual cancellation? No. Because of the word "and". So, twin requirement nga eh. So, again, even if the 30-day period has lapsed, actual cancellation of the contract will not happen until the full payment or full settlement by the seller of the cash surrender value. So pag hindi ka pa nabibigyan ng cash surrender value, pag hindi pa na-return sa'yo yung cash surrender value, walang cancellation. So again, in that case, that's another grace period on your part. No? So as long as these twin requirements are not fulfilled, then you can still have the chance, you still have the chance to pay because wala pang actual cancellation. Okay? So next, what is a cash surrender value? So again, as I said, real estate are, of high value, they increase in value, and that therefore, if there is a cancellation of the contract, it is but right to return to the buyer 50% of the total payments made. Okay, so the seller shall refund the buyer the cash surrender value of the payments on the property previous amortization made, equal to 50% of the total payments made. Now, if the contract runs 5 years, no? So nasa 6th year of installment ka na. Let's say nasa 7th year of installment ka na. There shall be an additional 5% every year, but not to exceed 90%. So let's say nasa 7th year of installment ka na, and then nag-default ka. So the total cash surrender value that will be given to you before the cancellation of the contract is 60%, because that's 50% and then 10% for the 2 years. So 50% for the first 5 years, and then 5% every year thereafter. So a total of 60% cash surrender value, but not to exceed 90% of the total payments made. So I hope that's very clear, ha? Again, so medyo mahaba-haba itong chance ng binibigay ng Maceda sa buyer. You are given, if you defaulted, you are given grace period equivalent to 1 month, no, for every 1 year of installment. So if 2 years, kasi 2 years na to, let's say 3 years or 4 years, that's 90 days. Kung 4 years, that's 120 days or 4 months. Okay? Now, pag nag-default ka pa rin, hindi ka pa rin nakakapagbayad within the grace period, we go to number 2. Okay? So, cancellation na ang contract, but you must be notified first. The notification must be notarized, no? And that the actual cancellation shall accrue 30 days after you are notified and upon full payment of your cash surrender value. Okay, so I hope that's very clear. So kung wala na, nabigay na sa'yo yung cash surrender value, na-notify ka na and bigyan ka na ng 30-day due process, so wala pa rin, so there will be an actual cancellation. So third, so the buyer shall have the right to sell his rights or assign the same to another or to reinstate the contract. So you have a right over the property, you can assign this to another. So yung yung sinasabi nilang ina-assume mo yung mortgage or ina-assume mo yung property, that's assignment of right. Because essentially, these are all contract to sell. So the buyer is not yet the owner of the property kasi nga contract to sell pa. But he can assign his rights over this property in favor of another. So who will probably assume the payment of the mortgage. So that's allowed. He could further reinstate the contract by updating his account. So the moment that you have updated your account during the grace period and before actual cancellation of the contract, then we will go as is. So again, the buyer is given many chances to settle its overdue account during the grace period and before the actual cancellation. Now, there is also nothing stopping the buyer to pay in advance. But when he pays in advance, the payment shall be without interest. So he need not respect the original term of the contract to sell. No? So he can at any time settle all the payments and then to have such payment annotated in the certificate of title. So if na-settle na rin niya, yung lahat ng payments, so you could ask for the certificate of title itself to have it transferred in his favor. Now, second option or second scenario, what I mean is second scenario, the buyer has paid less than 2 years of installment. So meron pa ring protection sa buyer, although on a lesser extent, because he is given a grace period of not less than 60 days. So doon sa more than 2 years, 30 days for every year of installment. Dito, a maximum of 60 days grace period. Okay? Now, the seller may cancel the contract after 30 days from the receipt by the buyer of the notice of cancellation or the demand for recession of contract by a notarial act. So just the same, after the grace period of 60 days and the buyer still fails to make true of his due payments, the seller may cancel the contract, but 30 days after the notice of cancellation. So again, this period the buyer can use to settle his accounts, okay? The notice of cancellation again must be notarized. So kung hindi notarized, hindi valid yon, hindi magra-run yung 30-day period. Okay, so just the same, the third and the fourth right, it's just the same with the first scenario. The right to sell, rights, or assign the same to another or to reinstate the contract, and also the buyer has the right to pay in advance. So, again, no, these Maceda law and Recto law are in conjunction with our civil code provisions, and it only applies to payment or sale of personal property and real property on installment. Okay, so I hope you understood these special provisions, and thank you for making it up to the end of my lecture, and I will see you soon. Thank you very much.